they interviewed or they investigated several people and they were able to rule all of them out. They didn't have a suspect for the longest time. The one thing that screwed Jaden and Larry's plan up
and your ability to reach out so quickly. So just keep that up. I appreciate it. And, you know, there's not been any issues. You know, you've been just continuous.
Good afternoon, Doug Lewis on behalf of Mr. Logan.
Good afternoon. Good afternoon.
I can do
I don't know.
March 31st at 2.
That'll work. That's Monday, correct?
Correct. March 31st at 2. All right, we will see you then. Fun continues.
Thank you, Judge.
Thank you. We are adjourned. Do I have Mr. Young and Ms. Hornbeak?
You haven't gotten that to me yet.
I found my taffy thing for my thing.
Yeah.
Oh, that is so sweet.
When Commissioner was in here, it got.
Oh, I have another one, a new one that I should put on to make it prettier now, since this has been on for so long.
All right, I'll go get Jackie and I and
You can sit over there, and then he,
Mark over.
yes, Mark over there. Thank you for finding that thing. I have a new one, but thank you for finding that.
I was.
I'm sorry, I think back in 2020, and then I got on Saturday.
Well, what you got on Saturday apparently was the motion for summary judgment.
Young versus Aaron Hornbeak and 24 SC 259, Mark Young versus Dan Hornbeak. Oh, Dan, you can come up there too. Questions already. I haven't even called the case. We have Dan Hornbeak, and now you've all messed it all up. Mr. Young, Mark Young appears in person without counsel. We have the Hornbeaks appearing in person without counsel. We're set today in this matter for de novo hearings. The matter was already heard in front of court commissioner. Mr. Young, I believe, requested to have de novo hearings in front of this court. That means it starts anew. It starts fresh from the beginning. You have to redo all that you've already done. So, Mr. Young, you had a question.
Yes, these are two separate cases, and the previous one.
I'm not doing them separately.
Well, I just want to talk to the one person that I'm done, and I don't want the husband to interrupt, or I don't want the wife to interrupt. I want to be the one that
Oh, Mr. Young, I get to control the cases because it's my courtroom and it's my rules, and that's how it's going to go. And if Mr. Hornbeak, if you're interrupting and you say something when I don't want you to say it, I'll let you know. And I'll probably let you all know very harshly and sternly, I control my courtroom and I control it well.
Great. That's all I wanted to hear.
All right. So, Mr. Young, this is your case against both Aaron and Dan Hornbeak. I don't see that we have any other witnesses. Therefore, I'm going to have all parties please stand, raise your right hand, and be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. All right, the burden is on you, Mr. Young, to prove your cases, and so you may begin.
Okay, it'd be easier if I talked about Dan's situation first because I met Dan through Carl Eberly Construction out of Balsam Lake. And Carl said Dan has been employed through him for 10 to 8 years. And I knew Dan for about 4 to 5 years. He is the foreman on Eberly Construction's crew. And Dan and his wife rented a house in Webster and paid the labor for rent in repairs to the house that they were in. And I bought a house at 24687 Anchor Inn Road.
I'm gonna have to tell you that if you're gonna say numbers or you're gonna say things, not only do I need to understand things,
Okay.
but my court reporter takes down every single word that's stated in here.
Okay.
And if you want an accurate record, you must speak slowly so that she can understand and take it down.
Okay. I purchased a residence on 24687 Anchor Inn Road in Siren on 11/16/2023. And it was in disrepair. There's an apartment that was livable, a 3-bedroom apartment that Dan and his wife rented from me. And it was understanding the rent would be the same as it was in Webster. His labor would work off the rent. And also in that agreement, there was 2 wood stoves there that Dan would have to cut the wood and keep them filled up for heat for the winter. There again, these wood stoves were in disrepair, and I had a guy by the name of Phil Kane repair them, and he wanted Dan's assistant in the repairs. And I paid Dan for his labor to repair this wood stove, and I gave him a total amount of $3,210 for repairing the wood stoves. And the rent was $850 a month, and the labor was at a $40 annual rate. 2 wood stoves we talked about, keep filled, and he had to buy half the logs. I bought half, he did. And there's also garbage service. And in my claim, I wanted to get the rent in cash, since Dan didn't do anything as far as the labor. The weather wasn't conducive, but he did do any of the labor.
And you didn't want to claim it for taxes, right?
Pardon?
And you didn't want to claim it for taxes, right? That's why you wanted cash.
That could be.
That could be, right? Yep.
So his half of the rent was $29.75. The other half would have been his wife, and that'd be in the other claim. And the half the logs was $1,500, $1,500. The garbage service for 7 months is $1,400. And like I said before, I paid him for helping Phil Kane of $3,210. Excuse me, I got a finger.
Are you adding figures?
Yeah, I'm just adding these figures up. I had it on a separate page, but I'm looking for that other,
I can add.
okay. The total was 8,675, Judge, on a total.
8,675, okay.
That's the total that I wanted to have Dan pay me for what I feel is correct. And that was just the background. I was telling you how I know Dan. And this was all verbal because I knew him well. And I sold buildings and Carl Eberly built them. And then Dan went on his own and also sold a building that Dan built for me. And he's a very competent carpenter.
Okay,
Yes,
that's all, that's it?
yes.
I have, okay. I mean, I don't have any other real facts to go on, but it's your case to see if you wanted to prove it. Okay, all right. So, are you going to move on to Aaron?
Yes.
Okay,
Erin was Dan's wife. And she also lived in the
well,
apartment.
let's make it simpler,
Okay.
just because since, are you done telling me all about Dan and why Dan owes you allegedly $8,675?
Correct.
All right, and you told me every fact you want me to know about why you think he owes you that money?
Right, because he had the same situation with Carl and I knew him well, and I thought that he would do the upright thing but
You told me all of the facts that you know to exist as to why, when, what.
Okay, looks like camera 3 and 4 are in operation. Mr. Bird, what's going on?
Figure it out for you. I know we not on both cameras.
Well, they're not letting me call in either one.
Your call has been forwarded. Just to let you guys know, Sam Ragnon just contacted me. He wanted to make a special appearance to do the women armed robbery. So
Are we off camera?
For Mr. Bonds?
No, he doesn't want to get off, so.
just to, to
Can you
kind
go
of
let Bertie
find
know what's
that out
going on?
afternoon.
He said they're not letting him in camera 3 or 4.
We're only on one camera, but I'll let him know.
All right.
Okay.
The Hamburglar joke was so much better. Never mind.
That was one of my best. Okay, so they're not on camera 3.
He's off camera 3, Your Honor.
They're not letting me call in. Let's make sure I got the right number.
148.59.61.10 pound.
Yeah,
1103.
it's not like I should know it by heart. Yep. Mr. Reagan's doing something today. Reagan's fault. Let's try camera 4. Well, it's not letting me in either camera. Okay, everybody, that's in the Zoom courtroom. I'm having some call issues logging into, the jail. So what I'm going to do is end this session and start all over, and I want everybody to log back in a few seconds. Once I'm going to log off and log back in and see if that does it. Okay?
Got it.
Yes, sir.
Okay.
So I sent it over.
See? Like that cartoon, and then it grew 3 times too big. 14A stands adjourned.
Included crime. The lesser crimes indicated in the definition of robbery are theft and assault. To prove the lesser included offense of theft, the state must prove the following 2 elements beyond a reasonable doubt. Jaden Devon Larry knowingly and unlawfully obtained U.S. currency of Dollar General. He did so with intent to either temporarily or permanently appropriate the property of Dollar General to his own use. To prove the lesser included offense of assault, the state must prove the following 3 elements beyond a reasonable doubt. Jaden Devon Larry intentionally and unlawfully threatened, either by word or act, to do violence to another person. At the time, Jaden Devon Larry appeared to have the ability to carry out the threat. The act of Jaden Devon Larry created in the mind of another person a well-founded fear that the violence was about to take place. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are dependent upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the state has proved your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Verdict. We, the jury, find as to the defendant, Jaden Devon Larry, as follows. Count one. The defendant is guilty as charged of robbery. The defendant is guilty of theft, a lesser included offense. The defendant is guilty of assault, a lesser included offense. The defendant is not guilty. Special findings. If you find the defendant guilty of robbery, you must further choose one of the following. We find the defendant carried a firearm during the commission of the offense. We find the defendant carried a weapon during the commission of the offense. We find the defendant did not carry a firearm or weapon during the commission of the offense, signed by the foreperson and dated. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way. and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberation. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, smartwatches, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those.
We don't have him here at DDC.
Okay, well, bring out Mr. Harris.
Harris.
Okay, go ahead, John, for you. Take the big chair. Okay, no, take the big chair. I need a break.
Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon. Sir, would you state your name, please?
DeMarco Harris.
Calling case number 25-05572-001 FH, the people of the state of Michigan versus DeMarco Alante Dejan Harris. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Good afternoon, Your Honor. May it please the court, Daniel Reed, P number 30965, appearing on behalf of Mr. Harris, waive form reading and stand muted this time.
Good to see you, Reverend Reed. Ms. Cole, good afternoon.
Yes.
The court will enter a not guilty plea on behalf of Mr. Harris. As it relates to bond, Ms. Coyle?
No objection to a $5,000 personal bond.
That is what we were requesting. We appreciate Ms. Coyle, and we appreciate the court.
Okay, court will set bond in the amount of $5,000 personal. Mr. Harris, sir, while you're on bond, you're not to possess or purchase a firearm or any other dangerous weapon. Do you understand that?
Yes, ma'am.
Okay, and you have 2 court dates. Your first court date is February the 18th at 8:30. That's a probable cause conference. Your next court date is in person. That's preliminary examination. And it's February the 25th at 8:30.
That's fine, Your Honor.
Okay, and both of those will be before Judge Jefferson.
We appreciate the court.
Okay, one moment. Oh, I have another condition. I apologize for Mr. Harris because it's a weapons charge. It's also a drug offense. So, sir, you're not to use any illegal controlled substances while you're on bond. Do you understand both of those conditions?
Yes, ma'am.
Okay. Do you understand your bond conditions and your court date?
Yes, ma'am.
Okay. Do we have anything further from the people?
Nothing, thank you.
How about you, Reverend Reed? Anything further?
No further. We ask you, Mr. Harris, call me when you get out, and maybe a few hours before they release you, but call me after you get out.
Okay.
Thank you.
Okay.
We appreciate the court.
Okay. All
Thank
right.
you,
Have a great day.
Thank you.
All right, DDC, can you bring out Victor Jones?
Victor Jones.
Yeah.
I haven't put the bond amount.
Oh.
I got you.
Yeah.
I know my first name.
Stand up right there. Turn around, please.
All right, Mr. Washington, you need a breakout room?
Yes, I do. Thank you. Thank you very much.
Good morning, Lloyd.
Well, go ahead. Stay here.
You gonna do them on the side?
No, stay here. Okay, accept the invitation.
President,
No, no.
In the breakout room. Mr. Washington.
I'm like, no.
No, no more problems, right? Okay, there we are on that one. He's got- Yes.
Well, go ahead. Let's see if they're done yet. Okay, you finished with the other one? Okay, okay. As soon as you see one of these, green goes away, you can close the room so that roll out and get started.
Are we outside? Good afternoon, how are you?
Okay.
Okay.
Yeah.
Not all.
Yeah. Okay, there you go.
Okay. Good afternoon, sir.
She called
Yes, will you state your full name, please?
Victor Jones,
What's your middle name?
Cleveland.
Okay.
And good morning, Your Honor. It's a pleasure seeing you.
Yes, good morning, Mr. Washington. Pleasure to see you as well.
Yeah.
Okay, Mr. Jones?
Yes, ma'am.
Sir, you have some tickets. So we'll call the tickets first and then we'll call your other matter.
Okay.
So we'll deal with the tickets first. Because you failed to appear, there were warrants that were issued.
It was a warrant?
Yeah, you failed to appear on.
Yeah, I talked to somebody down in 36th District. Well, I talked to like the ticket people. And I had failed to renew my ID from my previous birthday. Told me before I go.
Sir, that's okay. I'm gonna set the capias aside.
Okay.
I'm gonna set the bench warrant aside, okay?
Yes,
And
ma'am.
right now, I'm gonna advise you of your rights. You have a right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. I'm gonna read the following tickets. Ticket number P 1539582. You're charged with urination in public.
Urination in public? Oh, excuse me.
That's the charge. And you could face up to 93 days in jail or a fine of $500 for that offense. You understand that?
Yes, ma'am. Okay.
So you're gonna receive a personal bond on the ticket and you have a court date of March the 14th. That's a pretrial that's scheduled before Judge Larry Williams in the 36th District Court. That will be by Zoom, okay?
I think I had Larry Williams on.
Okay, sir, let's move on to your other matter.
Okay.
Calling case number 25-055-714-01 FH, the people of the state of Michigan versus Victor Cleveland Jones. Appearances, please.
Jennifer Douglas for the people, P72748.
And good afternoon again, Your Honor. Earl Washington, Neighborhood Defender Service, 231383 on behalf of Mr. Victor Jones. And we waive the formal reading of the information and stand mute.
Okay, did you also advise your client of his constitutional rights, Mr. Washington?
Yes, Your Honor.
Okay, the court will enter a not guilty plea on behalf of Mr. Jones. As it relates to bond, Ms. Douglas?
Your Honor, Mr. Jones, if people wouldn't object to a 5,000 personal bond, this is not an assault of Mr. Jones has a lack of history, so no objection to 5,000 personal.
And that's what we were going to ask for. It's a personal bond.
Okay, court will set bond in the amount of $5,000 personal. Mr. Jones, that means that you don't have to post any money. However, you have a condition. You're not to possess or purchase a firearm or any other dangerous weapon. Do you understand that?
Yes, ma'am.
Okay, and so you have 2 court dates. You actually have 3 because you have a date on the tickets. That's March 14th. But you have a probable cause conference that's scheduled for February the 13th. That's by Zoom. That's at 8:30, and that will be before Judge Kevin Robbins. Then you have a right to a preliminary examination. That is scheduled for February the 20th at 8:30, and that will be in person before Judge Taylor. Do you understand those court dates?
I have one question. Okay, my niece lives in Denver. She plays. I have my plane ticket to go visit my niece in Denver on the 20th. Could I please reschedule for after the 23rd of February?
Hold on, sir.
Yes,
This
sir.
is the other magistrate burden. You'll have to contact the courtroom to get your court date changed. We have no authority to do that. Okay, if there's no further questions, please step aside.
Okay.
Step out, sir.
All right, thank you.
When you tell you, we give you all that information where you can call the court to handle all your court dates.
Okay, one more question.
All right.
All right. Have a good day.
5,000 personal run on Harrison Jones.
Straight down the list. Bye, Mr. Washington. You have a good weekend.
All right. Have a good day to both of you.
Okay, you too.
Yeah, he's not there. Oh, Earl. Did I lose DDC?
Looks like it.
I guess they might have heard "Have a Good Day" about that's all we had.
You know that. Oh, Jesus. Oh, here we go. Okay, straight down the list.
Hello?
Hi, how are you?
Hello, sir. Who would you like to see next?
Mr. McCormick.
McCormick.
Hi, what's your name, sir? Speak slowly.
Gary.
Okay. This is case number 250-443-6901. People say Michigan versus Jerry McCormick. Appearances, please.
Well, appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Gary McCormick. My client waives his right to the formal reading, was violating his constitutional rights, will stand mute.
All right, the court are not guilty plea on behalf of Mr. McCormick. Bond recommendation from the people.
Your Honor, he was arraigned on the 4th for a MDP at the same address. And his bond he was given was a 5,000 personal. That same day, they issued a warrant for this case. It wasn't, I'm sorry, they didn't issue it till 2 days later. It was presented on the same day. The people are asking because Mr. Phillips is an 89-year-old man. He's in his wheelchair. I'm asking for no contact again with this
Mr. Phillips or the apartment building. My understanding is the defendant is a vet that has some issues with post-traumatic stress disorder. He's been told to stay away from that address. I'm asking for a personal as well, and no contact with the complainant or either complainant, Mr. Phillips or his son, and that address as well.
No objection, Your Honor.
Here.
Good afternoon, Attorney Cole.
Okay, Mr. McCormick, $5,000 personal bond, no contact with Mr. Phillips or his son. You can't go back to the St. Antoine address where this incident allegedly occurred. Pre-trial, February 19th, in front of Judge Bryant. Mr. McCormick, do you have any questions regarding your bond and/or court dates?
Yes. No. No.
Yes, no, maybe.
No.
What do we got?
No. I don't have no question.
Okay. All right, step aside there.
That size for me. Bonds.
Bond is $5,000 personal bond.
Yes, sir.
And bring out Charles Bonds. Charles.
How you doing, sir?
All right, what's your name, sir?
Charles Bonds.
All right, Mr. Bonds, you have two cases. Case number 250-5555-001. Let's start with attempted murder amongst other charges, and case number 250-557-0701. People versus Charles Bonds, armed robbery amongst other charges. Appearances, please.
On both matters, Steve Vincent for the people. Good afternoon.
Yes, Your Honor. Brandon Bird on behalf of Charles Bonds. My client waives his right to the formal reading and will stand mute.
Okay, with respect to both cases, the court rendered a not guilty plea on behalf of Mr. Bonds. I assume you're asking for a cash bond, Mr. Vincent?
I'm asking for a cash bond on the incident date of 11/1/24 with the lead charge of assault with intent to murder. I'll be asking for $1 million there. We have two victims that were stabbed. One of those victims was stabbed in the neck, allegedly by this defendant over at the slushy spot as a result of an argument that he had with the male who was stabbed in the neck. In the armed robbery case with the offense date of 12/14/24, I think there are two lead charges there, armed robbery twice over. I'm going to be asking for a remand under 6.106B1B. This is where allegedly the defendant ended up pistol whipping an individual and then at gunpoint taking all of their money. And then with the other individual that was with the first individual that got pistol whipped, he ended up holding that individual up at gunpoint and ended up stealing all of his money. In that case, the defendant was positively ID'd as the offender. So respectfully in that AWIM $1 million in the multiple armed robbery cases remand.
Mr. Bird?
18-year-old lifelong resident, Your Honor. One child, indicates to us that he lives with his girlfriend. Indicates to us that he's not on probation or parole, works with his grandmother at a church with kids with autism. Unfortunately, he'll be unable to afford any amount of bond in this matter. I do understand the severity of these allegations, but I'm not about to ask you for a personal bond on this because I know that probably is not even possible, but he still is innocent unless proven guilty beyond a reasonable doubt. And we respectfully just gonna ask for some sort of cash bond, preferably a low 10% bond seen fit by the court, but some sort of cash bond, even though that would be like a remand to my client, Your Honor. And if we are going to give a cash bond on one, I'm just asking for a cash bond on both of them. So both of those could go to the redetermination here.
Okay, court has heard argument as to bond. What I find very, very troubling is that these two cases, although last year were from November and December of last year, and to The report indicates that he's 19 years old, Mr. Byrd, not 18. Although I could be wrong about that, but the information I have that he is 19 years old. You said he's working. Did he finish high school?
No, Your Honor.
Okay.
No, he made it to the 11th grade.
Okay. All right. The court is troubled not only by the nature of both instances, these allegations, assault with intent to murder, allegedly stabbing somebody, and then armed robbery within such a short period of time. And like I said, one case is bad enough. Two, one can argue, if these allegations are true, that he is a danger to the community. And so with respect to the assault with intent to murder case, I will give him a $1 million cash surety bond as requested by the people for the reasons previously stated. I do find that he's a danger to the community. And with the armed robbery, I'm going to give him another $1 million bond on both of these. For the same reasons for both. I find that he is a danger to the community and to and so that Mr. Byrd can get his wish in terms of a boundary determination with respect to both cases. While these cases are pending, sir, you're not to possess any handguns, firearms, other dangerous weapons, no contact with Victor White or Landers Brunson, and no contact with Christian Warren. If you're able to make bond on both cases, you'll be fitted with a GPS tether house arrest. Bond redetermination on both cases will be Monday, February 10th, 9 a.m. in front of Chief Judge McConaughey. Probable cause, February 18th. Preliminary examination, February 24th, both in front of Judge Jefferson on both cases. Do you have any questions regarding your bond conditions and or court dates, Mr. Bonds?
Yes. Do I get a 10%?
Not today.
And I got a question. I got a how do I got an armed robbery attempt when I ain't never armed robbed nobody? You know, I'm not that kind of person. You know, and I'm going to school to get my GED right now, and it's kind of messing me up. You know, so I be watching my son, I get my son every day. Can't see my son, and to even hear that
Mr. Byrd, can you address that?
Just please, you're gonna get it. You're gonna get a redetermination hearing coming up down the line. But for right now, I doubt if the judge is gonna change his mind, just due to we only have the facts on the report, and I advise you not to speak about the facts. I advise you not to speak about the facts within the case, especially over this screen, because we got prosecutors in the room and it's being recorded, and everything you say could be used against you, even if you think it's trying to help.
Well, most definitely.
Okay, step aside, Mr. Bonds.
Who would you like to see next?
Next would be Jesse Ivy.
Ivy.
Is this Burger King? I get to have it my way?
Okay, so like, take your hand off.
Hi, sir. What is your name?
Jesse Ivy.
Okay. Mr. Ivy, how are you?
Okay.
Mr. Ivy, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. Court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to the attorney. You can't afford an attorney.
Yes. Oh, okay.
If you can't afford an attorney, one will be appointed on your behalf. The tickets are P1032426, failed display a valid license driving an unregistered motor vehicle. Ticket P1134630, driver license not valid. Ticket P1219204, driver license suspended, driving an unregistered motor vehicle, no insurance misdemeanor. Ticket SP1223702, driver license suspended. Ticket SP1223702 and 23, driving an arrested motor vehicle and no misdemeanor, no insurance misdemeanor. Ticket P1227506, driver license suspended, driving an arrested motor vehicle. Ticket P1237230, improper plates. Ticket P1522084, driver license suspended. Ticket P1582291, no insurance misdemeanor, driver license suspended, repeat offender. Ticket SP1582293 and 932, allowing unlicensed driver to drive, improper plates. In each of these misdemeanor matters, so you're going to personal bond or dollar amount pretrial March 13th in front of Judge Michael Wagner. Now to your main matters. Case number 250-557-1301, Peterson, Michigan versus Jesse Ivy. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Jesse Ivy. My client waives his right to the formal reading and will stand mute.
Court will not guilty plea on behalf of Mr. Ivy. Bond recommendation from the people.
Your Honor, I do understand this is a non-assaultive offense, but the circumstances surrounding it are a little bit different. So I will respectfully make this argument, asking for a $10,000 cash surety, tether, house arrest. Mr. Ivy's convictions go back to 2006 as an armed robbery as a juvenile, 2011 unarmed robbery, fleeing and elude third. His HIDA was revoked and he went to prison for that. Also, he had 2 subsequent non-offensive RCSP motor vehicle in 13 and 2021 CCW. But in this case, as the court has read, there's a traffic stop. They do an inventory search. They see 2 shell casings on the passenger seat. As they're walking up, as they're there, they also, the witness tells the officers that he's been threatening her home. She shows him where the gun is hidden in the vehicle. They also found that the gun was stolen, and that on 2/5, which is the day after this arrest, he's in jail awaiting today, and they pulled a jail call, and that he's not only referring to the hidden compartment, and he made indirect threats to this witness. So people believe that he's a danger to the community as well as to this witness, Your Honor, based on his own words. And we've got 2 shell casings found. We've got the gun was found missing 2 rounds. So based on that, Your Honor, the people are asking for that $10,000 cash surety tether house arrest. Thank you.
Bird.
Let me start with the basics, Your Honor. 36-year-old lifelong resident of Michigan indicates to us that he has 3 kids, lives with his grandmother, that he's not on probation or parole, and doesn't have any pending cases. He is employed, works Monday through Sunday, or Monday through Saturday, Your Honor. Morning shift. Respectfully, these are non-assaultive allegations. The state has the ability to bring any charges that they want against them, and they chose to bring these charges. If he was making indirect threats, that would have been a witness intimidation charge. Especially after reading this report, Your Honor, I recognize that they did put his stash in quotes. And then they say, additionally, Mr. Ivy made several indirect threats. They could have put those quotes in there. They could have put those quotes in there too. But for some reason they didn't. For some reason they didn't charge him with witness intimidation in this matter. There's multiple reasons why other people in the car might make up a story against somebody. And I don't want to make any assumptions that are true, but there's also potential that they could be forced to actually take some heat away from them. And maybe that's the reason why we don't see those charges. So respectfully, Your Honor, since these are non-assaultive allegations, I'm going to ask this court for a personal bond in this matter. We don't have anything else against my client. As mentioned before, the state has the ability to bring the charges they want, and they chose to bring non-assaultive allegations at this moment. Now, if they want to charge him with witness intimidation or anything like that, if they have enough evidence, then they'll be able to do that. But as of right now, I guess they don't have enough evidence or to bring those charges. So respectfully, we're going to ask for a personal bond on these non-assaultive allegations.
Your Honor, I just want to make it clear for the record, when I refer to her as witness, I just don't want to say her name on YouTube. She is not a witness in a court case where he can be charged with witness intimidation. So I just want to make it clear that when I refer to her as a witness, because she's a witness to where the gun was found, she's not a witness in which he can be charged with some sort of bribery or tampering. So I want to make sure that's clear for the record.
Then
That's
they
clear.
they can charge him with malicious telecommunicate. You use a malicious.
Mr. Bird. I don't want you to go down that rabbit hole. I got the gist of your point, and Mrs. Cole, you clarified the record, so I get both of your points, and they're both points to be taken as well. I am inclined to give him a personal bond, but with a GPS tether to make sure that he has no contact with the person Mrs. Coyle is referencing. And although I don't normally do that for gun cases, I will put a no contact order with respect to her.
And her residence, I would add.
Yes.
Thank you.
And so I'm going to give him a $25,000 personal bond, GPS tether, 9 p.m. to 6 a.m. curfew. No contact with the person referenced by Mrs. Coyle. I'm not going to put her name on YouTube, and her address as well. Probable cause, February 18th, preliminary examination, February 24th, in front of Judge Jefferson. While his case is pending, sir, you're not to possess any handguns, firearms, or other dangerous weapons. Do you have any questions regarding your bond conditions and/or court dates?
No.
Okay, step aside, please.
Thank you.
Mrs. Coyle, I don't have the address of the person. Can you send me the address in chat, please?
Yeah, I will look it up right now.
Thank you. What's your name, sir?
Larry O'Neill Lake Jr. Service.
Okay, give me 1 minute, Mr. Lake. Okay, Mr. Lake, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside court's going to set aside those arrest warrants. No.
You're not finished?
Okay. The court's going to set aside those arrest warrants, give you a personal bond in each of these misdemeanor matters that have a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent Anything you say can be against you. You have a right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The tickets are U603 11921. Trespassing. Ticket U603 17121. Trespassing. Ticket U603 111121. Trespassing. Ticket U603 11221. Trespassing. Ticket U603 11321. Trespassing. Ticket U603 17321. Trespassing. Ticket U603 17421. Trespassing. Ticket U603 17621. Trespassing. Ticket 2172788021. Loitering. That's a change of pace. Pretrial, March 13th, in front of Judge Perkins for all these misdemeanor matters. Now to your main charge. Case number 250-443-7501. Crusade, Michigan versus Larry Lake. Appearances, please.
Thank you, Magistrate. Steve Vincent for the people.
Yes, Your Honor. Brandon Bird on behalf of Larry Lake. My client waives his right to the formal reading and will stand mute.
All right, the court will enter not guilty plea on behalf of Mr. Lake. Bond recommendation from the people.
Magistrate, unfortunately, the people will be requesting under 7656A 1,010% cash surety bond. We'll also be asking for some type of monitorization. I think Magistrate Delphia Burton ended up handling matters regarding Mr. Lake in her prior life. And now we have an individual who is awaiting sentencing on 2 current cases on a personal bond for retail fraud in the 2nd degree. We have a defendant who just ended up spending time in jail in December after pleading and getting sentenced on a 2nd degree retail fraud. Prior to that, in October of last year, the defendant pled and was sentenced to jail time as a result of retail fraud. If you go into the ROA, it appears as though in the last couple of years, this defendant has over 20 cases that have gone through 36 district court. So respectfully, we're asking you to invoke the 7656A as well as monitorization.
Mr. Bird.
48-year-old lifelong resident of Michigan, Your Honor. He was forthcoming about his criminal history, Your Honor. My client suffers from multiple physical and mental issues. And I do understand he may have had a lot of cases, but we're dealing with a retail fraud and a retail fraud second, non-assault, Your Honor. And respectfully, we're gonna ask this court for $1. And he won't even be able to pay that. He can't afford any amount. He can't afford any amount of bond. Unfortunately, his disabilities don't allow him to work. Not sure if he's still receiving SSI, Social Security in this matter. So I do understand he has a lot going on, but we're gonna ask this court. We're gonna ask this court for $1, Your Honor.
Okay, Mr. Vincent, I respect your request under 765.6A, but I think it would be better if I just gave him personal bond, GPS tether, house arrest.
Your Honor, I have a tether already, Your Honor.
You have a tether? How long have you had that tether?
I just got it. I didn't have time to go back to the parole office because to make it in time. But I do have a tether right now at the moment, and I have to see my parole officer in the morning, Your Honor. So I will keep the tether on at all times, and I will make my court appearances, sir.
All right, Mr. Vincent, does that change in your bond argument? If not, just give me your thoughts.
Whatever you feel is most appropriate. I mean, unfortunately, this incident occurred just 2 days ago. So,
Yeah.
so that means that he was on tether when this incident took place. So I don't think tethers are going to stop him. But of course, I'm always going to concede to the way that you see things. And if you feel it more appropriate to go a different route, I'll respect that.
And I'm not sure if he had house arrest, Your Honor. I'm not sure if he had house arrest, that condition, at the time he had the tether. So that is a condition in which he would have to stay in the house, or he will end up back in the Detroit Detention Center.
Mr. Lake, what are your tether conditions? Do you have a curfew?
Yeah, yes, Your Honor, I have to be in the house. And, I don't know if I have a curfew, but I think I'm supposed to be in the house before midnight.
Well, that's a curfew.
Yeah.
All right. GPS tether, house arrest. I'm gonna give him a personal bond.
All right, I have a teller already, Your Honor.
Well, you may have another one.
How'd you get another one?
$50,000 personal bond, GPS tether, house arrest.
Okay.
Pre-trial, February 19th in front of Judge Bryant. Sir, I don't think locking you up will do anybody any good. However, based on what Mr. Vincent argued, I don't think giving you that nominal bond would do anybody any good either. But I want you to stay home. You'll be placed on the house arrest. And hopefully you can get the help that you need and not be a terror, an arguable terror to the community based on your past criminal history. So I'm taking a chance on you, sir.
Thank you,
I
think this
is the least restrictive means. I don't think you need to be in the custody of the Wayne County Jail, given your health issues and that you got to deal with. I think you need to be home. I think you need to stay home.
Thank you, Your Honor.
Okay, pre-trial February 19th. Step aside, sir.
What do I do with the teller that's already on me, though, Your Honor?
Oh,
the teller that's already on me. I already have one.
Sir, they'll tell you what to do. Step aside.
Okay, yes, sir.
Goodwin. What's your name, sir? This is case number 250-557-1501. Case of the Michigan versus Edward Goodwin. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Edwin Goodwin. My client waives his right to the formal reading and will stand mute.
All right, the court will enter not guilty plea on behalf of Mr. Goodwin. Bond recommendation from the people.
Your Honor, Mr. Goodwin's 18 years old. I am not aware of any criminal history for him. No objection to a $5,000 personal.
Mr. Bird?
No objection, Your Honor.
$5,000 personal bond, Mr. Goodwin, while the case is pending. You're not to possess any handguns, firearms, or other dangerous weapons. Is that clear, sir?
Yes, sir.
Probable cause February 13th in front of Judge Kevin Robbins. Preliminary examination February 20th in front of Judge Giles. Step aside, please.
What was the amount of that personal, Your Honor?
$5,000 personal.
Thank you.
You're welcome. What's your name, sir?
Beaches Blackwell Estes.
All right. Sir, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants and you post a bond in each of these misdemeanor matters. Excuse me, that carries a massive penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to an attorney. Can't afford an attorney, one will be appointed on behalf. The ticket is P128426. Improper place. Pre-trial for this will be March 14th in front of Judge Tanisha Yancey. Now to your main matter. This is case number 250-557-1801. People State of Michigan versus Demetrius Blackwell Esters. Appearances, please.
Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Demetrius Blackwell Esters. My client waives his right to the formal reading and will stand mute.
All right, the court will enter not guilty plea on behalf of your client. By recommendation from the people.
Magistrate, it's non-assaultive. I have a fleeing conviction, but it was about 7 years ago. With that being said, we're not going to object to a personal at this time.
No objection, Your Honor.
$5,000 personal bond, Mr. Blackwell. Probable cause February 19th. Clinical examination February 26th, both in front of Judge Taylor. Step aside, sir.
Where you at?
What's your name, sir?
Charles Mitchell.
All right, Mr. Mitchell, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside the arrest warrants for your personal bond and each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to an attorney. Can't afford an attorney, one will be appointed on behalf. The ticket is P1140333. Improper plates, driving a rest motor vehicle, no insurance misdemeanor. Ticket P1140459, driver license suspended. Ticket P1193565, driver license suspended. Ticket 484833, improper plates. And each of these misdemeanor matters, so you're given a personal bond, no dollar amount. Pre-trial, March 13th in front of Judge Michael Wagner. Now to your main matter, calling case number 250-557-1701. Police of Michigan versus Charles Mitchell. Appearances, please.
Jennifer Douglas for the people, P72748.
Yes, Your Honor. Brandon Bird on behalf of Charles Mitchell. My client waives his right to the formal reading and will stand mute.
Court will not guilty plea on behalf of Mr. Mitchell. Bond recommendation from the people.
Your Honor, Mr. Mitchell, I know the court can see his priors. He also had a 2024 attempt R&O conviction. We do have some concerns here given the allegations. This appears to be mutual combatants, and so the people aren't expressing concern necessarily for that complaining witness, or not